This podcast is brought to you by the School of Advanced Study, University of London. All of our podcasts are available from our website, www.sas.ac.uk.
Thank you very much. I would like to thank the Refugee Law Initiative for its hospitality, and in particular David Cantor for his kind invitation to deliver a lecture in this well-known university. So the topic of my presentation will focus on the normative interactions between human rights law and refugee law at the international level, not from a domestic law perspective. I mean, generally speaking, international refugee law and international human rights law has been initially conceived as two different branches of public international law, grounded on different instruments and supervised by specific international organizations. It is well known indeed that on the one hand, the main source of international refugee law at the universal level is the Geneva Convention, relating to the status of refugees, adopted in 1951 and amended by the New York Protocol of 1967. And while the primary responsibility for implementing refugee law relies on states, the UNHCR, the United Nations High Commissioner for Refugees, has been established as the main international organizations in charge of refugee protection. From the other side of the coin, international refugee law is based on, at the universal level, of the two UN covenants on civil, political rights, economic, social and cultural rights, adopted in 1966, and also a wide range of more specific instruments. I mean, the Convention Against Torture is the most well-known. And here again, while the main duty bearer of human rights is still the state, the High Commissioner for Human Rights and a large number of treaty bodies are in charge of supervising states. So this is the general picture. So while grounded on different instruments and supervised by specific institutions, the interaction between refugee law and human rights law is now well acknowledged by states and scholars. However, the normative impact of their relations has been rarely apprehended through a systemic perspective. And this seminar will be the occasion to explore the relations between refugee law and human rights law from a holistic and critical angle. And from this angle, the relations between refugee law and human rights law have evolved around three successive narratives: preventive, interactive, and integrative. I will briefly develop the three successive narratives. Originally, the relations between refugee law and human rights law have been approached as a causal link. I mean, the violations of human rights being acknowledged as a primary cause of refugee movements. This is the preventive approach. Since then, the conceptualization of their relations has shifted from a preventive to an interactive approach. This interactive approach has mainly focused on the specific linkages between human rights and the refugee definition, the principle of non-refoulement, I mean the core components, the core specificities of refugee law. And now, more recently, the interactive approach has paved the way for a more integrative one. I mean, by integrative approach, I mentioned the complementary or subsidiary form of protection to refugee status under the Geneva Convention. So, despite this substantial evolution, still today academic discussions remain relatively specific and refugee law oriented, to the detriment of a more systemic analysis. And in fact, refugee lawyers are used to celebrate the virtues of the Geneva Convention as a vital source of refugee protection. And by contrast, refugee lawyers generally consider that the other human rights instruments would be too general, not relevant, or based on inappropriate assumptions for protecting refugees. And against such a frame, I will simply argue that this professional bias in favor of the Geneva Convention is no longer tenable. On the contrary, human rights law has radically informed and transformed the Geneva Convention to such an extent that the normative frame has been displaced from refugee law to human rights law. And as a result of this systemic evolution, the terms of the debate should be inversed. Human rights law is the primary source of refugee protection, while the Geneva Convention is bound to play a complementary or even secondary role. So this is a rather unorthodox assertion, which is grounded on a comparative assessment of applicable norms under both refugee law, human rights law, and this normative inquiry is focused on the three major pillars of the refugee protection, which will be the three parts of my presentation, namely access to international protection, the content of protection, and then the implementation scheme. Regarding access to protection, access to international protection is primarily conditioned by two parameters, quite well known: refugee definition and the principle of non-refoulement. And these two critical components express the very essence of refugee law, the very essence of the Geneva Convention. The refugee definition and the principle of non-refoulement crystallize the specificities of refugee law, and in the meanwhile, they reflect the major impact of human rights law on the Geneva Convention. Let's briefly develop this first assertion. Regarding the refugee definition, the scope of refugee law and human rights law represents the most obvious difference between the two branches of public international law. Human rights are applicable to everyone because of the dignity inherent to every human being, whereas the benefit of the refugee status depends on the identification of a predetermined category of protected persons, the refugees. And this refugee definition is rather restrictive regarding the structure. The selectivity inherent to the refugee definition is reinforced by its very structure, which is composed by three different levels of requirements: exclusion clauses, inclusion clauses, and cessation clauses. I will not develop each of them because they are well known, the different clauses of the refugee definition. And this selective approach, of the refugee definition, has been substantially informed and to some extent mitigated by the subsequent development of human rights law. The impact of human rights law on the refugee definition is primarily grounded on two basic reasons, two main factors. First, human rights law provides a universal and uniform set of standards, which represents a particularly persuasive device for harmonizing the unilateral and frequently diverging interpretation of state parties to the Geneva Convention. Second, given the subjectivity inherent to many key notions of the refugee definition, human rights standards offer a more predictable and arguably objective normative frame for determining who is a refugee. So I can mention several examples, and I don't want to go too much into details, but clearly the very notion of persecution illustrates the impact of human rights on refugee law. Defining persecution by reference to human rights has become a conventional wisdom for both states and scholars. And the impact of human rights law on the refugee definition is not limited to the notion of persecution. It also concerns the grounds of persecution. Race, religion, political opinion are clearly linked to basic human rights, whereas race, nationality, membership to a particular social groups are clearly encoded within the principle of non-discrimination. But we can also mention many other examples. The notion of non-state actors of persecution has been also framed by human rights law, the internal flight alternative, cessation clause, and so on. So, in sum, regarding the refugee definition, human rights law has proved to be instrumental in promoting a common and dynamic understanding of the refugee definition, in line with the subsequent evolution of the international law. A similar evolution can be observed with regard to the principle of non-refoulement. As we all know, the principle of non-refoulement is clearly the cornerstone of international refugee law, grounded on Article 33 of the Geneva Convention. On the other hand, human rights law has considerably impacted on the principle of non-refoulement. The human rights principle of non-refoulement is endorsed in several conventions against torture, conventions against enforced disappearance, and several other regional instruments. And of course, besides these explicit endorsements, the general prohibition of torture, degrading, and inhuman treatment has been interpreted by treaty bodies as inferring an implicit prohibition of refoulement. This was done by the European Court, but also the Human Rights Committee, the Committee for the Rights of Child, the African Commission of Human Rights, and so on. So we have principle of non-refoulement with two different bases, refugee law and human rights law. The human rights principle of non-refoulement coincides in substance with its refugee law counterpart through the notion of degrading treatment, because in substance, or at least in practice, the notion of degrading treatment under human rights law equates with the notion of persecution under the refugee definition. So there is a convergence between the two. However, human rights law provides a broader protection than refugee law on three specific issues, which are also well known. The human rights principle of non-refoulement is not subordinated to the 5 grounds of persecution required by the Geneva Convention. Second, the refugee definition exclusively applies to a person who is outside the country of his nationality, whereas no such geographical limitation is required under human rights law. And the third, and probably the most well-known characteristic, relies on the absolute nature of the human rights principle of non-refoulement. Its use applies to asylum seekers and refugees who have been excluded from the Geneva Convention. So these three added values of human rights law are emblematic of the impact of human rights law on refugee law. They not only supersede the more restrictive protection under international refugee law, but they also reveal in turn the distinctive rationale underlying each branch of law. In other words, refugee law is bound to grant protection only to those who deserve protection, whereas human rights law is universal and inclusive in essence. This is the first part, focusing, and the most well-known aspects, focusing on access to protection and the importance of human rights law for interpreting the refugee definition and enlarging the principle of non-refoulement. Let's continue with the second part of my assessment, namely the content of international protection. Because one distinctive characteristic of refugee law, frequently mentioned, relies on the refugee status. So the refugee status under the Geneva Convention has been heralded by commentators as establishing the Geneva Convention as a primary source of protection, relegating to use human rights law to a secondary role. This is the conventional wisdom. However, a closer examination of the content of protection under the Geneva Convention and the other human rights treaties reveals a completely different picture. And I can mention two main arguments. First, Compared to the refugee status, human rights law is broader than refugee law with regard to its personal and material scope. I will come back in a few seconds. And second, and probably more fundamentally, human rights law supplants refugee law even when their respective norms overlap. Concerning the first argument I just mentioned is quite obvious. I mean, human rights are by definition applicable to everyone, including to asylum seekers who are not addressed by the refugee status, because states limit the benefit of the refugee status only to duly recognized refugees with few exceptions, Article 33 and Article 31. So clearly human rights law and the legal status of asylum seekers is primarily grounded on human rights law rather than instead of the Geneva Convention. But human rights law retains its centrality for asserting the rights of refugees duly recognized as such under the Geneva Convention. Indeed, human rights law proved to be essential for ensuring additional rights which are not guaranteed by the Geneva Convention. And in fact, the range of human rights supplementing the refugee status is very substantial. Two particularly critical rights for refugees which are not guaranteed by the Geneva Convention are the right to family unity, which is a major right, and the right to return. But we can also mention many other examples of additional rights guaranteed by human rights law and not explicitly established under the Geneva Convention. I mean, even very basic rights, right to life, is guaranteed by human rights law and not by the Geneva Convention, prohibition of torture, prohibition of slavery, freedom, even freedom of expression, equality of right, equal right of men and women, and so on. So, I mean, human rights law considerably enlarges the scope of the refugee status. But besides granting additional rights to refugees and asylum seekers, human rights instruments prove to be more adequate and more protective even when the rights in question are already covered by the Geneva Convention. I can mention here many examples such as freedom of association, freedom of movement. The most important example is probably the principle of non-discrimination, because the principle of non-discrimination is guaranteed by the Geneva Convention, but also by human rights treaties. And the non-discrimination clause is contained in Article 3 of the Geneva Convention, and this provision is limited by three substantial qualifications. First, this provision only prohibits discrimination between refugees and among refugees. Second, the prohibited grounds of discrimination under the Geneva Convention are restricted to three grounds: race, religion, or country of origin. And third, the scope of Article 3 is circumscribed to the application of the provision of the Geneva Convention. So this only prohibits discrimination in the application of the Geneva Convention. By contrast, the principle of non-discrimination under human rights law is much more inclusive, because prohibited grounds of discrimination under human rights law are not exhausted, but also, the principle of equality before the law provides a freestanding protection against discrimination, which is not limited to a particular right. So, clearly, both in principle and in practice, Article 3 of the Geneva Convention has been largely neutralized by human rights law. And I can continue with several other examples, but let's continue with, after this brief survey of the content of international protection, which proved to be more protective under human rights laws than under refugee law, let's continue with the third and last part of my assertion, the implementation scheme. The implementation scheme is another way to apprehend the relations between refugee law and human rights law. Following a traditional perspective, the Geneva Convention draws a clear-cut distinction between the international norms contained in the Geneva Convention and their national implementation. So, the refugee definition and the principle of the refugee definition and the refugee status are internationally grounded, whereas the link between the refugee definition and the refugee status, asylum procedures, is not covered by the Geneva Convention. The Geneva Convention says nothing about asylum procedures, which are primarily governed by domestic law. From the perspective of human rights law, the situation is quite different, because here again, human rights law plays a key role by compensating for the absence of procedural guarantees in the Geneva Convention. In particular, the right to an effective remedy is crucial in link with asylum procedures. The right to an effective remedy is guaranteed by all human rights treaties. It ensures two main guarantees. It requires an independent and rigorous examination of the asylum claim. And second, the effectiveness of the domestic remedy requires that any removal must be suspended during the examination of the asylum request. So, human rights law play here a crucial role by filling the procedural gap of the Geneva Convention in the field of asylum procedures. I can also mention the prohibition of arbitrary detention as another examples, but let's continue with another aspect, because human rights law provides additional guarantees, additional procedural guarantees which are not mentioned in the Geneva Convention. But the same observation can be done with regard to the supervisory mechanism of human rights law and refugee law. Compared to human rights law, the supervision mechanism provided by the Geneva Convention is rather traditional, if not clearly rudimentary, because the final clause on settlement of dispute establishes the International Court of Justice as a primary means for settling disputes between states. And this possibility has been never used, maybe fortunately, because the International Court of Justice is not well known for being a progressive institution. But anyway, as a compromise to this quite state-centered mechanism of implementation, UNHCR has been conceived as the guardian of the Geneva Convention. Under Article 35 of the Geneva Convention, states have the obligation to collaborate with the UNHCR. But here again, the UNHCR plays clearly a key role by providing interpretative guidance on the Geneva Convention. But from the enforcement side, enforcement-related activities remain the weakest side of the mandate of UNHCR. It's the inability to assume enforcement activities and a proper supervisory mechanism is generally attributed to the fact that the UNHCR is both politically and financially dependent on states. And we can maybe later further develop this point. So there is no independent mechanism for monitoring the Geneva Convention. And the lack of an independent mechanism for monitoring the Geneva Convention sharply contrasts again with the control-oriented paradigm of human rights law. As you know, all human rights treaties are supported by their own treaty bodies, specifically mandated to monitor state compliance through the promotion, at least at the UN level, through the promotion of interpretative standards, through the processing of interstate and individual communications, or through the examination of state parties' periodic reports. So, of course, human rights treaty bodies are not the panacea, but they contribute within their own mandates to filling the institutional gap of the Geneva Convention, which has no independent supervisory mechanism. And in the meanwhile, the contextual and clearly dynamic interpretation of treaty bodies has been so instrumental that the two branches of international law are now intimately interdependent. I mean, human rights law and refugee law are bound to work together in tandem, because my conviction is that the cross-fertilization process between refugee law and human rights law can be found in the very existence of the human rights treaty bodies, because treaty bodies have counterbalanced the normative and institutional weakness of the Geneva Convention. And today, as a result of a gradual normative process, international refugee law and human rights law become so interdependent that it is now virtually impossible to distinguish one from the other. Nevertheless, a closer examination of their respective norms clearly demonstrates that human rights law has become the primary source of refugee protection, and the Geneva Convention has been accordingly relegated to a supporting role. On the other hand, human rights law has considerably refined, reinforced, and sustained the Geneva Convention. And probably human rights law has given a second life to the Geneva Convention through a dynamic interpretation of the refugee definition, through the reinforcing the principle of non-refoulement, and so on. Refugee law today can no longer be divorced from human rights law, and I would argue further, refugee law has been absorbed by human rights law. I know that this is not very orthodox for refugee lawyers, but my conviction is that human rights law has become the new orthodoxy of refugee law. I mean, refugee lawyers must be also human rights lawyers, and the fetishism of the Geneva Convention is no longer tenable. Human rights law requires a holistic approach. And what is interesting in this holistic approach promoted by human rights law is that this approach may renew with the traditional function of asylum. Because asylum is not only an act of protection. Asylum is also an act of affirmation against another subject of law, which is unable to hold its primary function. In essence, granting asylum reflects the judgment that the state of origin, the refugees, has failed to fulfill its duty of protection and has accordingly lost its legitimacy. Of course, I mean, this is a disturbing consequence of the importance of human rights law. But assuming refugee law as an integral part of human rights law calls for revisiting the international regime of protection as a whole, and it also requires states of origin to face their own responsibilities. I mean, to conclude, I would like to quote a well-known US scholar, Enkin, who summarized the key issue of this interaction between human rights law and refugee law in the following terms. I quote, "In some and in a few words, not only compassion but responsibility, not only individual state responsibility but collective responsibility, not only the Refugee Convention but the International Covenants and the UN Charter, not only UNHCR but the Human Rights Committee and, if necessary, the UN Security Council." Thank you very much for your attention.